Welcome viewers to the Personal Injury Law Show. This is a show that talks about everything to do with personal injuries in Victoria and also Australia. We talk about transport accidents, work accidents, slips and falls, medical negligence. My name's Tony Carbone, personal injury lawyer of over 25 years experience. With me tonight I've got John Karantzis, an accredited specialist. Good evening, John.
Good evening, Tony. Good evening, viewers.
And also Dean Hergina, another lawyer of many years experience in work cover and transport accidents. Good evening, Dean.
Good evening, Tony. Good evening, viewers.
Tony, what's in the news tonight?
There's been a lot of stories in the news, viewers, but the one that I want to talk about tonight, the first one is about a doctor who was sued by a lady who now suffers from brain damage. Just briefly, the facts were a lady, 57-year-old, she was a fitness fanatic in the sense that she was 5 days a week walking. She keen on looking after herself, John.
Tony, she was a healthy lady of her age. She wanted to lose some weight, so she went to a GP. He prescribed a medication called Reductil.
Yes, Reductil.
No tests were ordered by the GP before prescribing. Now, what's happened, Tony?
Well, the effects, and Dean, what happened was this. She's putting on weight, but she's walking 5 days a week, and she feels fatigued.
And she doesn't know why.
Surprisingly, no blood test. Do you think you'd order a blood test in those circumstances?
Well, you think you take every precaution, particularly if the side effects seem to be going opposite to what it's supposed to be doing. So, not sure what the doctor was thinking there.
Well, what's strange is that these days you sneeze and they order a blood test.
Exactly. Every time you see a GP, they say, yeah, go to this specialist, go to that specialist. In this case, she's repeatedly gone to see the GP and really nothing's been done. And what's happened to her?
Anyway, she had a condition called hypothyroidism,
Yeah,
which
basically
is an underactive thyroid.
Exactly.
Anyway, she took this medication, which is now no longer used. She got brain damage. She lost her case. The jury came back and said there's no negligence because, as her barrister quoted, not everything that happens is someone else's fault. So a failure to diagnose, and she's got brain damage. I'm astounded.
Tony, it's a very tough decision. Basically, she has sued the doctor for negligence in that he has not acted within his duty of care to take care of her and to make sure that the medications that have been prescribed for her will not damage her and were appropriate. Unfortunately, the jury in this case, 6 peers, have come back and said that really the doctor did nothing wrong.
I'm astounded, I really am.
Anyway,
it's on appeal, viewers.
It's a very tough decision, Tony.
Telling me. The other one I want to do is an employer was cleared in the Court of Appeal of a truckie prank. These fellows are working together. Unsuspectingly, the plaintiff, the guy comes behind him and whacks him on the knees, sustains nasty injuries.
Yes.
What happened in the Court of Appeal, John?
Tony, it's pretty harsh on the worker in the sense that he has sustained a severe back injury. He can't work again. This happened in 2001. We are now in 2012. The Court of Appeal has said by a split decision, 2-1, that basically the employer is not responsible for the skylarking of one of their employees.
Dean, the court said that it's not reasonably foreseeable that a fellow employee would do what this particular defendant did. How can it not be foreseeable? People are skylarking and mucking around all the time.
Yeah, it sounds like they're running a playground, not a respectable workplace. And the employer was obviously in the vicinity when this occurred. It sets a very bad precedent and an example going forward for employers to say, well, I can't control what someone else has done.
Tony, it makes it tough for workers now in the sense that the argument of foreseeability that work have raised continually, well, this just enhances it, doesn't it, Tony?
It does, but I'm glad that it was a split decision because it means that it's not really concrete, set in stone.
Well, Justice Neve of the Court of Appeal, Supreme Court of Victoria, said that this was in the course of employment. So, look, it isn't solid, but at the same time, it makes it tough.
The message to viewers is this. If you're the person that's playing the prank, what will happen in the future is if the employer's not responsible, then the person that's played the prank that's caused the damage will get sued as well. And then that's going to make an interesting situation and precedent. Because say you're the one that's come behind, whack, you'll be held responsible. And so you better have insurance, because I'll tell you what, you will get sued and probably get bankrupt at the same time.
At the same time, I guess, Tony, that is for common law damages.
Yep.
The worker still is entitled
To no-fault benefits.
to no-fault benefits, which include weekly payments of compensation and medical-like
That's
expenses.
exactly right.
But really, that's little comfort, isn't it, Tony?
That's exactly right. The topic of conversation tonight, viewers, is what is manual handling? That is, we're talking about work scenario, OH&S legislation, and what employers and employees have to do to protect themselves. We're talking about, I know it sounds obvious, but it's about how you lift, how you twist, how you turn, what posture you keep, heavy loads, light loads, repetition, all that sort of stuff.
And also the responsibilities of the employer in providing a safe workplace and in providing assessments of this type of duties, Tony.
Especially with the background of the Accident Compensation Act, the Occupational Health and Safety Act and regulations, and just the common law in general.
Exactly.
Dean, I want to do the first case of Hopgood and Wodonga Regional Health Service, 2012 Victorian Supreme Court decision. Can you give me the facts briefly?
Yeah, just briefly, this was the injured worker was a nurse working in an emergency department. A patient walks in complaining that he can't breathe, he collapses on the floor. She's looking for assistance with the emergency department. There's no one available, so she goes to this man herself. She sees that he's quite big and obviously will cause her perhaps discomfort if she moves him, so she looks around, there's no one to assist. What happens, she's got no choice but move the patient to his side to clear his airways. In doing so, she feels an extreme sudden onset of back pain. She keeps working through, having no choice, and as a result of this incident, sustains very serious injuries.
John, if she didn't take the action she took, this patient would have died, I think.
That was her evidence at trial, Tony, before a jury, before a judge and jury of the Supreme Court of Victoria. Justice Beach heard this evidence, and basically it was that her evidence was, I'm there at 6:30 in the morning, I can see he's turning blue, I needed to do something. If I didn't do something right then and there, he would die. Now she's trying to pull this person who was over 130 kilograms, and she's a lady of slight frame, and she sustains injury to her middle back.
Viewers, we've got to go to a sponsors break. We'll come back and let you know what the court did in this case. But in addition, I want to go to some video footage of a work cover ad dealing with manual handling. So please stay tuned.